Okay, and we are in Senate institutions. Today is Friday, February 28th, and we are continuing our walkthrough of S71, which is an act relating to consumer data privacy and online surveillance. And we have Rick Sagel, Legislative Counsel, here to take us through the walkthrough. So I will turn it over to you, Mr. Sagel.
Yeah, good afternoon, Rick Sagel, Office of Legislative Counsel. And we are on S71. And we left off on page 32, section 2419, the duties of controllers. So I'll just start off on that section. So do I need to give a little bit of what we're talking about yesterday? It's been so recently.
Really in a hurry. So,
okay,
so give the minimal amount.
Yeah. So this is where you have some language beginning specific things for, in this case, controllers to do. In this case, subsection A is what a controller shall do. And I'll again highlight some of what I think is important for you all to consider, even though you should read the whole bill and ask me questions when you have the question. But limit collection and processing of personal data. Remember, personal data is different than sensitive data, and there are limitations of what personal data means. Limited to what is reasonably necessary, proportionate, to maintain a specific product or service requested by a consumer, and a communication that is not had by the controller to the consumer that is reasonably anticipated within the context of the relationship between the controller and consumer. A controller shall establish, implement, and maintain reasonable administrative, technical, and physical data security practices to protect the confidentiality, integrity, and accessibility of personal data that is appropriate to the volume and nature of the data at issue, including disposing personal data in accordance with a retention schedule that requires the deletion of data when it's required by law or no longer necessary for which the purpose the data was collected. Subdivision 3, provide an effective mechanism for a consumer to withdraw consent. That is at least as easy as the mechanism to which the consumer provided originally the consent. Okay, so B1 is a few things related to minors. And again, there's maybe some overlap here with the age-appropriate design code. A controller that offers any online service, product, or feature to a consumer who the controller knows is a minor, more about that in a second, shall use reasonable care to avoid any heightened risk of harm to minors by processing their personal data. Provide to the minor a conspicuous signal indicating that the controller is collecting the minor's precise geolocation data and make the signal available to the minor for the entire duration. Notice that's different than in kids code where it's the parent or guardian or really anybody that is tracking the location of a minor. This is about the data that is being collected. And C, not process the personal data of a minor for the purpose of targeting of targeted advertising, or importantly, sell the personal data of a minor. So a controller cannot sell the personal data of a minor. So how does the controller know if a consumer is a minor? Subdivision 2. Knows means a controller knew or should have known the consumer is a minor. And how do you know or should have known? It's kind of a reasonable person standard, but we do give some direction here. Based on information collected about the age of the consumer or any age or closely related proxy the business knows or has inferred, derived, attributed to, or associated with the consumer for any purpose, including marketing, advertising, or product development. In the kids code, we had this age assurance stuff that businesses had to adopt at some point, and the agent could help them with that. In this case, we're not providing that age assurance method. We are kind of giving them ways to determine the age of their consumers, but something to think about. If you want to be more prescriptive here, you can certainly do that. Or again, let the AG help them determine what age assurance looks like. However, nothing should be required nothing in this chapter should be construed to require the affirmative collection of any personal data with respect to the age of users that the controller is not already collecting in the normal course of business, or a controller to implement an age gating or age verification functionality. The reason it's out there, the courts have been very clear that states cannot require age verification. That's been a pretty clear I'm gonna say edict, but direction from courts is that you cannot require just basic age companies to use age gauging or age verification. Okay, a controller shall not process sensitive data except when it's necessary, strictly necessary, to provide or maintain a specific product or service requested by the consumer. They shall not sell sensitive data. Yep.
Just one, to be clear, this is not restricted to minors now.
This
This
is-
is everybody.
This is everybody.
Okay.
Good question. Yep, everybody. Discriminate or retaliate against a consumer who exercises the right provided under this chapter or refuses to consent to the processing of personal data. And this subsection here, this C, this is where you start having, you'll see later the private right of action. So these are what is deemed to be very, very important to consumers and maybe the most protective for consumers. So what you're seeing here is if a controller does violate one of these subdivisions, selling sensitive data, discriminating based on a consumer who doesn't consent, you're going to see later on a potential private right of action for these.
Thank you.
So discrimination by denying consumers goods or services, charging different prices or rates for goods or services, or providing a different level of quality or selection of goods or services to the consumer. They shall not process personal data in violation of state or federal laws that prohibit unlawful discrimination. And except as provided in the next subdivision, process a consumer's personal data in a manner that discriminates against individuals or otherwise makes unavailable the equal employment goods or services based on some protected classifications there. However, that shall not apply to a private establishment, think like a private club that you may be a member of, that is allowed to discriminate on the basis sometimes of age or sex or other protected classifications. Processing for the purpose of a controller's or processor's self-testing to prevent or mitigate unlawful discrimination or otherwise ensure compliance with state or federal law, or processing for the purpose of diversifying an applicant, participant, or consumer pool. Okay, so again, that subsection C is really, really important. Subsections A through C shall not be construed to require a controller to provide a good or service that requires personal data from the consumer that the controller does not collect or maintain. Prohibit a controller from offering a different price, rate, level of quality or selection of goods or services to a consumer. Think of it as your grocery card rewards card, where you can, if you're a member, you get discounts on your groceries, you save certain, or a gas station rewards card where you save how many cents per gallon. So this subdivision here is meant to make that as a exception. Controllers are allowed to do that if you are a bona fide consumer with a bona fide program.
And just, it says with consent.
With consent, which, usually the terms when you sign up.
Yeah.
So you cannot prohibit a controller from doing that, however, unless the transfer is necessary to enable the third party to provide a benefit to which the consumer is entitled. And the terms of the program clearly disclose that personal data will be transferred to the third party or to a category of third parties. And the third party uses the personal data only for purposes of facilitating the benefit to which the consumer is entitled and does not process or transfer the personal data for any other purpose. The sale of personal data shall not be considered functionally necessary to providing financial incentive program. Okay, beginning F is a very, very long subsection here. And this is the basically privacy notice. I'm not going to read through this one. This is one that you can kind of see what would be required of a controller's privacy notice that they must make available to consumers. I'm going to highlight one, but Madam Chair, if you don't mind,
No, that's
that's
fine. And
maybe the best use of time here is.
yeah, I think so. I appreciate you calling it to our attention. So it's a meaningful privacy notice.
Right.
It's the,
Which, most companies do already have a privacy notice. Various other laws may require this. Again, make sure, and you'll hear from testimony that may say it's too onerous or something else, or it's good or bad. But it's detailed, and you kind of see exactly what this law would require to be in the privacy notice.
Okay.
But I do want to highlight one that is important, maybe more important. Page 38. This is J, subdivision J. So in the privacy notice, it must provide a clear and conspicuous description of any processing of personal data in which the controller engages for the purpose of target advertising, sale of personal data to third parties, or profiling the consumer in furtherance of decisions that produce legal or similarly significant effects concerning the consumer, and critically, a procedure by which the consumer may opt out of this type of processing. So this is, again, allowing the consumer to opt out of this type of processing. And we're going to refer back to this subdivision later, where the controller must give the consumer a way to do this. So you're informing the consumer they have this right. Now you actually have to provide a right to do these things.
Thank you.
Okay.
I'm gonna have a question about why isn't the second part a procedure in a separate paragraph, but that's not for talking about now. I'm just giving you a heads up.
Okay. Let me think about it when I'm not.
Yes.
Yeah. Okay. Subdivision 2, just describing that the notice shall adhere to accessibility and usability guidelines required by federal law. 3, that when the controller makes a material change to this privacy notice, he must notify consumers affected by the change, either on your website, your app, or maybe through email. The controller shall take all reasonable electronic measures to provide notification regarding these material changes to affected consumers, taking into account available technology and the nature of the relationship. They don't have to provide a Vermont-specific notice if they have a notice that would otherwise cover this law. So that's a way for businesses to just have one notice that they give to everybody, no matter where they live. 5, the privacy notice must be posted online through a conspicuous hyperlink, using the word privacy or surveillance, or both applicable. Again, read through that. At the last sentence, if they don't operate a website, they shall make privacy notice conspicuously available to consumers through a medium regularly used by the controller to interact with consumers, including email. G, we're referring back to the F1J, which I pointed out. The method or methods under the subdivision for submitting a consumer's request to a controller must take into account the ways in which consumers normally interact with the controller, the need for security and reliability in communications related to the request, and the controller's ability to authenticate the identity of the consumer. Provide a clear and conspicuous link to a website where the consumer or an agent may opt out from a controller's processing of the consumer's personal data, or solely if the controller does not have capacity needed for linking to a web page. Provide another method the consumer can use to opt out, which may include a hyperlink. You can see that there. 3, allow a consumer or authorized agent to send a signal to the controller that indicates the consumer's preference to opt out of the sale of personal data or targeted advertising. That is consumer friendly and easy for an average consumer to use.
Is average and medium as well too. Is average consumer defined in statute either federal or state? Is that just up to the current argument?
Right, and it would be the judge or the jury that would determine if this was what the business was doing, the controller was doing, was easy for an average consumer.
So if it's not the attorney, do you think I'll have an average consumer?
I don't know, you won't. That's under Douglas.
Okay.
Yeah.
Yeah, and we can talk about that more.
Okay.
Maybe not use.
Senator Douglas, in my eyes, you are always above that.
Thank you, Senator Baker. I appreciate it.
BI, still talking about this opt-out mechanism, enables the controller to reasonably determine whether the consumer has made a legitimate request pursuant to 2418B, and for purposes of the previous subdivision, use an IP address to estimate the consumer's location may be considered sufficient to accurately determine residency. Okay, if a consumer uses the method opt-out of the controller processing and the decision conflicts with the consumer's existing controller-specific privacy setting, the controller shall comply with the opt-out preference, but may notify the consumer that, hey, you have conflicting information here. What do you want us to do? Giving the controller a way to settle that confusion.
And so in essence, you're saying either opt the consumer out or ask the consumer.
Mhm.
If, you know,
If the consumer requests an opt-out, that they be opted out of targeted advertising or processing. But they have some other, let me go back here, if they have some other setting that the controller is aware of, that since they opt in, then what's the controller supposed to do, right? So in this case,
all right,
they should, but the opt-out is, in this case, the law would say, no, you prioritize the opt-out. However, the control can also say, hey, we're gonna opt you out, but you're telling us two different things here.
no, I misunderstood, so thank you.
Yeah. Questions about duties of controllers? Okay,
I mean, we will have some in the future, but
sure.
this is good.
Okay, 2420, duties of processors. So remember, a processor follows controller's orders and how they process the data that a controller has on the consumer. So they shall adhere to a controller's instructions and shall assist a controller in meeting their obligations under this chapter. In assisting the controller, they must enable the controller to respond to requests from consumers pursuant to 2418B. And by means that take into account how the processor processes personal data and the information available to the processor, use appropriate technical and organizational measures to the extent reasonably practicable. Adopt various safeguards that are reasonably designed to protect the security and confidentiality of the personal data the processor processes, taking into account how the processor processes the data and the information available to the processor, and provide information reasonably necessary for the controller to conduct and document data protection assessments. B, processing by a processor must be governed by a contract between the controller and the processor. The contract must be valid and binding on both parties, set forth clear instructions, nature of and purpose of the data, the type of data that's being processed, specify the rights and obligations of both parties with respect to the subject matter of the contract, ensure that each person that processes the data is subject to a duty of confidentiality, require the processor to delete personal data or return the data to the controller at the controller's direction, unless law requires otherwise. Require the processor to make available to the controller at the request all information the controller needs to verify that the processor has complied with the obligations. Require the processor to enter into a subcontract with the person the processor engages to assist with processing personal data on the controller's behalf. And in the subcontract, require the subcontractor to meet the processor's obligations concerning personal data. Allow the controller, the designee, or a qualified and independent person the processor engages in accordance with appropriate and accepted control standard framework or procedure to assess the processor's policies and technical and organizational measures for complying with the processor's obligations under this chapter. You might be wondering why the processor's being required to help the controller so much. It's because the controller, in order to comply with the chapter, needs the processor's help. So this is ensuring that the processor has the legal, is required under the contract that they have to assist the controller in helping at the end the consumer do what the consumer wants. Continue on. Require the processor to cooperate with the assessment and at the controller request, report the results of the assessment to the controller. Prohibit the processor from combining personal data obtained from the controller with personal data that the processor receives from or on behalf of another controller or person or collects directly from the individual, and require the processor to adhere to equivalent or greater de-identification standards. Sections not relieve the controller or processor from any liability that accrues under this chapter as a result of the controller's or processor's actions in processing the data For purposes of determining obligation under the chapter, a person is a controller with respect to processing a set of personal data and subject to an action under 2424, which is enforcement. We'll get to that. If the person A does not adhere to controller's instructions, B begins at any point to determine the purposes and means for processing the data. So here the law is clarifying that, because remember, the duties of controllers are much different than the duties of processors. Controllers are held to a much higher standard. So what the law here is trying to make clear is that if a processor is doing things that a controller would do, that processor is going to be called a controller under this law. So the law does not want a processor acting like a controller to be treated like a processor, if that makes sense.
Yeah,
Okay.
no,
Clear as
no
mud?
road, yeah.
Okay.
No, that B paragraph is pretty
Yeah.
clear.
Okay. 2, a determination under the subsection is a fact-based determination. 3, a processor that adheres to a controller's instructions with respect to a specific process and person data remains a processor. So also making clear that this law does not want to make every processor a controller. If a processor really is a processor, then they should be treated as a processor. I've never said processor so many times in 20 minutes. Okay.
Doing great.
2421. You can think of this section as, no, sorry, it's the next one. These are your data protection assessments. Now I will say that this is not every data privacy law has this section. Okay, these assessments, I think New Jersey may have it, the one they recently passed. So this is a fairly new thing that is in this law. So just highlighting that.
Can I make a suggestion? Since we have to be on the floor in 7 minutes,
Mhm.
can we stop right here since this is a natural break?
Probably. I think that does make sense. Is there anything that you want us to know in 2 minutes?
About this section.
Yeah, or about just what we know so far and what we're gonna do. I mean, we can read it over the break, maybe. Folks can do that.
Am I coming back after your
Oh, yeah, I'm sorry.
floor time?
Yes, hopefully. We'll
Yeah.
see.
Okay.
If our floor, because you only have until,
I emailed the other committee. I've not, my email's not open, but
okay,
once
so.
we're offline, I can tell you my schedule.
Okay, so if we can come, members of the committee, just come right back here as soon as the floor is done, please. But we will not go past 2:30 and I expect we'll not go past 2. Okay,
Yeah, I asked for 1:45.
Okay. that's good,
Yeah.
that's right.
Yeah.
Yeah, okay, so 2. We'll
I can quickly give you maybe, 2 minutes here if you, after the chair, what you want me to do here?
Well, I think unless there's wrap up, do you want to do any wrap up?
I mean, it's kind of right in the middle of the bill. So
Yeah,
how much to wrap up?
Yeah, so just to be clear, we have to be on the floor at 1, which is in about 6 minutes now. I don't know how long the floor will be, but this committee will come back here afterwards, unless I make a different announcement on the floor. Okay, and we'll be done likely by 2. Okay, is that good?
Did you see that face?